guys, it's Kathy. I hope you're doing well. Oh, my poor mods. I told them days ago, okay, guys, we're going to do a stream 9 o'clock a.m. on Sunday. And then last night I hit them with, hey, can't do it at 9 a.m. I got called into work. So we're going to do it at 4:30 a.m. And then I overslept. And I just started it at 6:30 and there they are in chat helping me out. I love my mods. They're so great. And my chat is so great. Hi, Shauna. Hi, Legal. Okay, I have this custody case. No, it's a custody case still going on, but this right here is it's a modification of child support that the father filed. The father filed this to lower it. And I don't know why. I mean, he's mad. It's not crazy. He's really mad, but it's different. You'll see. Hi, Jim. Hi, Monica. Hi, Cha. Here we go.
Without additional clarification, we're just having a guess here as to what that issue in particular was.
Yeah, and I think if it's not contested as to once all of the other determinations are made going back to October, that there might be some additional balances for the court to consider that will change that number. So if there's no significant dispute as to...
There is.
What is that, sir?
I was the original person who filed this request for modification of child support in August of 2023. The hearing of October 1st was based on my request for modification. That being that I was unemployed from January to September 25th. I requested relief because I was on unemployment. And it just so happened that the scheduled hearing took place as I was reinstated for work. But there was an 8-month period which I did not work, and that I requested financial relief as a hardship because I had no income coming in except for unemployment, which I had child support withholding removed from my unemployment benefit. That was exhausted, and fortunately I was reinstated on September 25th, and I didn't request anything beyond October to be reduced. I fully expect to have both of our incomes considered and to pay child support at the full amount beginning October 1st. I'm not requesting anything after October 1st, simply before, at least when I made the request in August. I can't ask for anything before August, but at least the 2 preceding months, August and September. That should be considered as a reduction at the minimum income level. Then moving forward from October, I agree to any full child support order that would come from the process of determining our incomes.
I'm not exactly sure what he's requesting, Your Honor, but
I think I understand. So let me summarize. Yeah, so I'm looking at that motion that was filed and endorsed September 29th, for which we had October 1 as the effective date. Now, the issue that you need to understand, and I'll let Ms. Haik-Bruno and Mr. Pasunas speak based on their understanding as well, is that the court can only consider time periods that are notice time periods for hearings that upon filing, okay? I'm not authorized by law to consider a time period for modification that is not properly noticed to include that time period. It can be done by party stipulation, or it can be done by court order. This process is by court order because there is no agreement for a different amount of child support for the period that you were unemployed for. Now, a lot of people have stated before, and DCS can also reference this issue, that unfortunately, if a request is made for DCSS to file, because of the volume of cases and clients that they deal with, they're not able to get to a party's request in a sufficient time frame to allow for immediate remedies of the fluctuation in income. It so happened that by the time this modification request was filed, it was close to a period where you were discussing and resuming work. So I am bound by the law, and I cannot consider anything apart from the effective date, which would have been October 1. But I'll let Ms. Bruno respond to some of that, what you raised.
Yes, Your Honor, I'm going over the logs as to what happened in the prior year. And I do see that the motion file on behalf of Mr. Axe was dated September 29, 2023, mailed September 8, 2023. So the first month that a modification would apply would be October. I understand his frustration, but as the court has articulated, DCSS just receives hundreds of requests to evaluate for modification. So if a party wishes to be heard sooner and preserve that date for retroactivity, that's when we point them to filing their own motion, just because it will take us at least a couple months to go over the paperwork.
You know, I just want to add that Mr. Axe filed his motion on September 29th, representing that he was unemployed. And that hearing was set on November 1st, where support was reduced from $1,415 a month to $270 a month because of his representation. The fact is that he was rehired on September 25th, 4 days prior to his filing. And then when he showed up at the hearing on November 1st, he falsely represented that he was continued to be unemployed. And then my client had to file a motion for reconsideration. And at the last hearing on January 31st,
right,
he acknowledged that he had,
that.
Yeah, that's what happened.
Right. So then I'm not keeping arrears on as an issue. Obviously, there will be some additional amounts that when we come back will change based on the court's orders for reimbursements related to dental, medical, and parenting time changes. And the last issue that I have is attorney's fees. Now, there were both then based on what Mr. Pasuna stated, both need-based and Family Code 271 fees for sanctions, which I'm adding.
I believe it's just 271, Your Honor.
There were need-based fees raised at the earlier 2030. So did you raise that, or did you raise that, Mr. Axe? Do you want attorney's fees?
I think we might have raised it, but I think—
I am not. I'm objecting to all attorney's fees and to the 271 and the 2030 and 2031.
I believe we raised the 2030, but I think based on their respective incomes, I don't think 2030 would really apply.
So you're just asking for 271 fees?
Right.
Okay, all right. So
that hampered us on the last hearing. That stalled us. That made us stall on the last hearing, and we consumed too much time regarding these attorney's fees on the last hearing we had. That's why we had to continue it to a hearing.
Actually, that's not accurate. We continued it because there was disagreement on a lot of issues, timeshare, income. And I believe there will be an arrears automatically once you go back to October 1st, because my client's income was being used at 7,000 something, and it's now the court's—
It'll change it, yeah. So, okay, so I'm adding 271, and I think you raised, was it the discretionary add-ons? Now, the issue that I have with adding a new component to what we already discussed is notice. If there's been no supplemental filing referencing the agreement or the amount that you state parties agree to cover for discretionary add-ons, I'm not inclined to add it, just based on your representation that might be disputed in the future.
Well, I think where there is an agreement, I just like to put on the record today that Mr. Axe has agreed to pay for half of the swim lessons that the children or swim team that they're doing. I think that's their agreement based on the text messages that I've seen.
What's your response, sir?
I have paid in full the entire amount of the swim team registration fee on the 19th of March. And I paid it to the child support services of the state DCSS. And it's documented $548.95.
he did make a payment of $548.95, but I mean, that goes to the child
It goes to
support.
support. Yes, Mr. Axe, it doesn't.
Swim team is something that they're supported by, right? What
I'm-
is the definition of support and what does it go to?
Okay, let me ask you this. I think this may clarify it, but go ahead.
I think that what Mr. Axe is trying to say is I pay for the swim through my child support. I don't think he's making it a separate. Am I understanding that correctly?
If from an accounting perspective, I want to make sure that you and DCSS and the court and Mr. Basunas are all on the same page, okay? So I want to make sure that we're documenting correctly all the payments that you make, because obviously there's an ongoing balance sheet, right? Regarding ongoing interest, what the ongoing amounts are. And eventually when we get to trial, we'll talk about some additions or subtractions based on parenting time, reimbursements, etc. So if the $548.95 represents swim, then I will not consider it and figure out from an accounting perspective if it's possible to not have it towards the running balance on child support or arrears. But I want to make sure then to see if DCSS can make that happen. And if not, then it might be an issue that this goes towards child support and not a specific activity costs, because accounting is going to be an issue.
So if perhaps today's order reflects that the payment dated March 19, 2024 should be credited to extracurricular and not arrears, then we'll be able to back out. We will be able to add $548.95 in arrears. If that does that achieve the purpose that the court is looking for?
Mr. Basunas?
I have no idea. I don't know how they're going to do that account.
So it would be complicated. What I will say though is because father is in arrears with child support, that payment he made was credited and was sent to mother. Again, that does not provide additional income. It just goes to the debt that father already has. So he did get credit for it.
But as child support and or arrears, but not for activity costs.
Correct.
Right. That's the issue. Do you understand that, Mr. Axe?
Now, give me 1 second, Mr. I'm trying to, in my head, try to figure this out. If the court would make an order today for $548.95 of that will go to extracurriculars, then we can open a bucket for that, and then we will recoup that bucket when more money comes in, if that makes sense.
That amount that I paid was for 2 children, the full amount. That was not half.
Okay.
So therefore, if we divided it in 2, it would be what, $270 or something like that.
Well, then father needs a credit of $270 for her half.
So I think the easiest way is if I state that that payment that he made was towards this swim cost and not towards child support arrears, and that based on father's representation and hopefully mother's agreement that this was the full amount and not half, then I think we give father credit and then consider this not an issue that needs to be raised.
That's fine, Your Honor.
And your client's okay with that?
Yep. Yeah.
All right. Okay. So then what am I stating on here? That father's paid $319 on March 19th, $548.95, which is for
Registration for swim team.
discretionary add-ons. And that he will receive 50% credit because this is the full amount and mother owes half. Is that correct?
Correct. So
Yes, ma'am, I did not anticipate that to be attributed at all to arrearages. It was designed for the swim team, but that it was the only way that I could document that I made a payment otherwise.
Right. But what I'll say is that I'm just, as an advisement, unless it's specifically court ordered for a purpose, you have to determine another method of payment for activity costs, especially if you and mother agree to that outside of DCSS's involvement, because we're going to have accounting issues otherwise.
Okay. And if I might add one more thing, that registration needs to take place immediately because their swim season starts next week. And if she doesn't register them within days, or even today might be the last day, then they won't be able to participate.
Mr. Pasunis, did you hear that?
I'm sorry, are my clients trying to, there's a $200 deposit?
Volunteer.
I don't know what that is. Can my client talk, Your Honor?
If you're okay with it, sure.
Fine.
So part of the obligation of the parent at the swim team is to do a certain amount, 65 volunteer hours during the event. And the parent is not able, due to the employment or living in the other city or whatever, they have to put $200 a volunteer deposit. And I refer Mr. Axe to the Rancho Cordova Park District to pay, to put this deposit down, because he didn't know, he wasn't able to do this because he doesn't have checks. So I can put this deposit down for him if he, if you add this 200 to the payment for the activity.
Split, so $100 each, is that what we're talking about?
But my client's saying because he's gonna owe Mr. Axe half of the money that we paid.
No.
This
Yeah,
$200
let me talk.
against that.
So this was my suggestion. So if they're each responsible for half, it's $274.50. I'm rounding up, it's 0.47, but I'm rounding up to 0.5. So I was going to request the court to add a note in the order after hearing that Mr. Axe was responsible for $274.50 for the swim meet. And since he already paid on March 19, twice as much, then the other 275 is a credit towards his arrears, because that money already went out to mother. So she already, basically father already had the detriment and mother received the funds. Does that make sense? Mr. Axe, does that make sense to you too?
An explanation of this, it's a deposit based on volunteering at each swim meet to set up, take down time, and so on like that. At the end of the season, that check, and the reason why they request a check, is torn up and shredded. They do not take the funds. So it's not cash money that they're requesting. They're requesting the volunteer hours. So it's not a monetary value. I can't.
Well, Mr. Axe, here's where I'm
You
going
can
to
put a
step in.
stipulation.
Mr. Axe, just a sec, okay? This issue is not on calendar. I'm wasting court time and resources in discussing something that we're kind of bending over backwards to try to accommodate. I'm willing to state that you will be receiving a credit of $274.50, but that is the extent to which I'm willing to accommodate. I issue this minute days last minute. I'm not going to go into the nuts and bolts of how this is going to work, what the expectations of the parents are, whether there is going to be volunteer hours or not. I am not going there. So then I think we have our issues identified. Let's talk about dates. Madam Clerk, I think where we're looking at the 16th, perhaps. What are the time estimates, Mr. Pasunis?
I think first they probably need 2 hours because and we should have a Bulgarian translator for this one.
Will you reach out and request?
Yeah.
We'll do it. It was just,
request.
yes, it was just an issue about everybody being tied up for today, but the interpreter's office indicated with sufficient time they would make somebody available.
So the only caution that I will add is that for interpreter matters, it's more or less double the time for time estimates, just because of the logistical part of it. So if you're looking at 2 hours
No, I'm thinking with the translator. I think
with,
with translator, like 2 hours for our side. And I really haven't gotten any real questions from Mr. Axe yet, but once we get a statement of issues, I probably will have some.
so my afternoon trials have about 3 hours, right? 1:30 to 4:30 on Fridays. So am I reserving more than one slot is the question.
I think this case deserves likely to be the only case that day. I know that sometimes we do a half and half.
So
Like today,
Right.
I think we would have spilled over if we actually had this
but you
hearing.
believe one afternoon is sufficient?
Yeah.
All right. So then let's look at like blocking out the other one for that day. So with nothing else that day? August 9th or the 16th, right? Or do we have something on the 16th? Okay, August 9th or the 23rd?
August 9th. Oh, is it possible to go to September?
Oh, yes, because we have the emancipation also, right? I think if we do, if it's just the child's emancipation, yeah, I guess it makes sense that we give September.
It does because there's arrears, so there's no risk that father is going to be overpaid.
Right, okay. So then I'm looking at September 6th. Do we have anything?
20th, not 3rd.
We have already booked out through September? Oh, okay. 6th and the 20th, okay.
20th, I have a file the 5th and 6th.
September 20th then? At 1:30.
I don't think I've heard father confirm that
Yeah, Mr. Hack?
available.
I have a question about custody, which is obviously a different case number. Can a motion be filed to modify custody independent of this information here?
Yes.
Okay, then, yeah, I have no problems or issues with September 20th. I can
All right.
agree with that.
I'm going to schedule for September 20th at 1:30. I want to set a deadline. Let me look at where we are on the calendar. I will say no later than August 30th. That gives the parties roughly about 3 weeks to have knowledge of everything that the other party intends to serve as exhibits. Now, Mr. Pasunas has requested trial briefs. You are self-represented, Mr. Axe, but what I'll say is you can use a form that's available on the court's website known as Statement of Issues. That's a form that's typically used for mandatory settlement conferences, which will allow you to kind of state what issues you feel there are, what your positions are regarding these issues, and how you can support them, okay?
Okay,
So those, along with income and expense declarations and all exhibits that the parties need to present to each other. And we are looking then at multiple parenting time periods. So DCSS has referenced logs. If you have any parenting logs that need to be disclosed, that you need to start making if you haven't already, we're still looking at a good 4-month period before that date, where you can still start and have parenting time be as close to accurate as possible.
and can I subpoena from the district attorney and from the Department of Child Support Services?
Sabina, what?
Everyone.
Visitation denials that I've recorded with the district attorney, and also the information that I need from conversations that occurred at the Department of Child Support Services on the phone.
Yeah,
Their notes.
I would say that conversations would be hearsay. So the Department
Objection.
of Child Support would
Hearsay.
not testify or provide logs. Again, we're bound by confidentiality and other matters aside. Just bringing up those issues for truth of the matter asserted would be hearsay.
Right. I would say, Mr. Axe, that if you have, I don't know, call reports or police reports or anything, you can certainly request them and make sure that they're served, and that both of you will have the right to raise any objections to when these exhibits are presented. just because the other party is served doesn't automatically mean that an exhibit comes in to be weighed by the fact finder. So you can certainly plan to be as prepared as possible. And I'm sure Mr. Pasunas also plans to do the same.
Okay, so, and I can call witnesses?
Yes, certainly allowed to call witnesses. Because you're self-represented, you may want to check in with self-help regarding subpoenas. You don't automatically have subpoena power, but there's a process by which you can participate through self-help for the issuance of subpoenas.
All right, thank you.
Okay.
Your Honor, exhibits, exchange, statements of issues, any parenting logs, and witness lists and income and expense declarations all have to be filed and served by August 30th.
Correct. Now, the question then is, what is the form of service? Are you both, going to,
We're filed electronic.
okay, and then Mr. Axe,
Electronic is fine.
the burden will be on you if you're appearing remotely to make sure that this is complied with. Because if DCSS doesn't receive like these exhibits, the court doesn't receive them, that there's going to be an issue with how you can present them, okay? So you're responsible to make sure that you have sufficient copies, that they've each of our different, stakeholders and participants and parties, et cetera, have the information that's needed. Or you can appear in person and then everyone's here and then you can then have the copies provided accordingly for the,
Well, they should have already been provided by August 30th.
correct. But
So-
typically parties bring it to court on the day of. The court doesn't need to receive them by the 30th. Just DCSS and each other.
Okay,
And Your Honor, I know the court is not inclined to hear testimony from the children subject to this order, but knowing that the oldest child would then be an adult and there is a timeshare discrepancy, would the court be open to having the oldest child as a witness to timeshare?
If the parents want to, my only caution there is that the parties asking the children to testify cannot be, forcing the children if they do not want to or telling the children what to say, which I'll make an inquiry of if that issue is raised. Okay.
Your Honor, I know the 271 sanctions were added, but as well as the additional cost for the continuance today because the request was untimely and not properly filed or served.
Okay. I'll add that.
Thank you, Your Honor. I think that's it on our end.
Okay. All right. So if just an identification of issues, just so everyone knows, took close to an hour. I would hope that we're ready to go when we come back and start the process without any further delay on the 20th of September.
They won't be.
Okay.
Thank you, Your Honor.
All right.
Thank you.
Thanks, everyone.
Thank you.
Okay. Bye-bye.
Thank you.
So that was just swim lessons. I don't even know how this hearing is going to go, guys. So one of the kids is about to be an adult. So that much we got. And that might maybe have been what they were talking about when they were talking about the emancipation of one of the kids, which it probably was. But he paid the full swim lesson. She wanted 200 more. They ignored her completely. Like she didn't even say anything at all. And then, he lied about his income at the first hearing. He's like, yeah, I was off from January till October. No, he was 2 months out of work and he got unemployment that whole time. So it's not like he was out of work with no income at all. And I know that unemployment isn't your full paycheck, but it's enough to pay for your children. The children are still there during those 2 months. They still need stuff. But okay, I get it. He pays a lot. It was over $1,000 a month for the 2 kids, which is a hell of a lot for child support. But apparently he makes a lot, so I don't know. I just think these 2 are just a little bit too old to be be worried about child support. As soon as I saw him especially arguing about child support, I was like, oh, yeah, I gotta get this one. Wait, I gotta check my mail. Ah, damn it. He sent me a subpoena, guys. You guys are gonna get one too. Anybody who is in this chat watching this, he's sending a subpoena to. All right, let's move on to Fleischer. So yesterday I played. I mean, his docket was pretty long, so I couldn't get all of the clips. So I finished it today, and I really hope that this pisses off one of the people in my commenters.
What's the word, man? A smile, that's a good thing. A smile's a good thing.
It's a great thing, Judge. It's Friday.
Friday.
I have Ms. Gallardo. May she be brought up? Bring her up. Yes, for plea.
Oh, you want to do a plea hearing? Okay. Yeah. You want me to sign this or electronic? Ms. Gallardo, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement where they're offering you 3 days in jail. Guys, keep it down. They are offering you 3 days in jail. Give you credit for the 1 day that you've done.
2 días que ya cumplió,
Oh, sorry, 2 days credit.
Desde el crédito por tiempo cumplido.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you are stuck with this forever.
Siempre, solo mira el juez.
Do you understand?
¿Se entendió, señora? Tiene que hablar, ¿sí, señor o no, señor?
No, ¿me puede explicar? Que no,
No, can you explain it? I didn't understand. ¿No me entiende a mí?
no, es que son muy ligeros.
You went too fast. Well, I gotta go fast because you're going fast.
You are giving up the right to a trial.
Derecho de un juicio.
You are pleading guilty to this offense.
Piensa.
Do you understand?
¿Entiende? Tiene que hablar. ¿Sí, señor o no, señor?
Sí.
It's
Yes.
going on your record.
Y sobre su expediente personal.
It will be on your record for the rest of your life.
¿Entendió?
You can never take this off if this is what you want to do.
Si esto es lo que usted quiere hacer, ¿entendido?
You give up the right to talk to witnesses. This also has potential immigration consequences. You can be deported,
Es que usted podría ser
excluded from the country,
excluida del país.
or denied naturalization. Mr. DeGuider, please. You give up the right to appeal,
Que va a apelar.
meaning that
Quiere decir,
you can never come back and try to change your plea of guilty.
ya tratar de cambiar su declaración de culpable, ¿entendió?
Is this what you want to do?
Yes.
You must also understand this is an enhanceable offense. If you ever pick up another theft, you will be facing a minimum of 30 days in jail.
That's it.
Do you understand?
¿Entendió?
A third theft case is a felony, and you will be looking at
Estaría enfrentando
up to 2 years
años
in prison.
en prisión, ¿entendió?
Be careful.
Tenga cuidado.
How do you plead to
¿Cómo
this
se
offense?
declara esta ofensa, señor?
Guilty or not guilty?
Culpable.
A ver.
Guilty.
I will find you guilty.
Seré culpable.
I will follow the agreement.
Perdón.
Good luck to you.
Una suerte, señor.
Thank you. Okay. Trinidad. Happy Friday, man.
Happy Friday, here. Young Mr. Andre Diaz here. He's here Monday. Oh, no, so he's here Monday.
Is everything done?
Not yet. We're still on a 9-month PTI. We're not letting him out.
Okay.
So he's here Monday. Today he went down there to go get a urinalysis. They told him it wasn't due until Monday. He asked, when he gets here, he asked if our priest trial service is here. It ain't done till Monday. Victoria's saying that he needs to have a urinalysis. Is it order from the court today or?
Yeah, I guess we can get Jeremiah to do it. Yeah.
Oh, what are we doing? Are we sending him and then he's gonna be back here Monday to do another one?
No, I guess let's just have him do one now, you know, and then,
He's gonna be back here Monday to do another one.
no, I'll give him more time.
You have him consecutively now, I think 10 weeks, every Monday. doing your analysis. Now, he had one Monday, now today, and then he's gonna do another one Monday. We're doing three.
No, that's too close. I don't want him to have to do
I
that.
understand that, Judge. I'm not the one.
So
I'm just trying to get it reset.
I don't know why someone said he had to come back on the 26th. Mr. Monday, and I gave him, they said the following Monday. He says, no, I want him to come back specifically on the 26th on drug test.
was that the day that after 30 days that we had said?
Yeah, I think today is just a regular reset for the case.
Right here, defendant was admonished that if he tested positive for marijuana on 4/26, that he would be taken into custody. And the next time he had a bond violation, no matter what deal was on the table, his case would be immediately set for trial. Those are the notes that I put on 4/1. He got to go get drug tested now. And I hope he doesn't test positive for weed. That's it.
There for me. Can I get a reset then after that?
You can get a reset if it's positive, it ain't gonna go well though, but you can get a reset for sure. Just sure. Yeah, I mean, and if it's negative, we'll waive it, you know?
Do another year analysis on Monday?
No. I hope he's just negative, right? Okay, hey.
Really quick on Bernard,
He won't be negative, guys.
and looking at the case file and everything, there is an offer on there, which my client may want to take today, just.
If he wants to do something, he's in the driver's seat. If he wants to do, it's up to him. I will take whatever you guys want to do. It doesn't matter to me. Yeah, for sure.
Hey, Judge, we had an off-docket arraignment come in this morning.
Okay. Let's do it.
All right, case number. It is 2506825. Ms. White, come on up.
Good morning. Are you Deja White?
Yes, sir.
Miss White, you were charged with assault of a family member. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews of the state of Texas. If you cannot afford a lawyer will be appointed to represent you, ma'am. Okay.
On April 22nd, 2024, officer was dispatched to Harris County, Texas, complaining because one was just the mom stated that the defendant got upset because she felt somebody had taken her belongings. Complainant number one was the defendant about her disrespecting her stop person.
Snacky snacks right by the microphone.
One stated that the defendant then pushed her hard with her shoulder, causing pain. Complainant one pushed the defendant back, stating that the defendant then began striking her in the face with the closed fist, causing her to feel pain. Complainant one stated that she began to try and restrain the defendant so that she couldn't hit her anymore. Complainant one stated that that complainant number two then grabbed the defendant, trying to pull them away from each other. No criminal history, Your Honor.
Ms. White, how old are you, ma'am?
17.
I'm going to find that there's probable cause to go forward with your case. How'd you get here today?
My godmom brought me.
So your mom's not here today. Are you godmom?
She's not here.
Where's your godmom?
She's waiting outside in the car.
Lies.
Who are you living with now? I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with your mother. I'm also ordering you not to be in possession of any weapons. If I find that you violate these conditions, I will put you in jail. You must understand that if I put you in jail, the only reason that you are out now in the free world is because you got a free PR bond. We, as judges, have the ability and the authority to revoke that, put you in jail, and make your bond as high as we want to do it. If you have no one to bond you out, you will be stuck in jail until the case is over with. And I'll tell you now that it takes almost 9 months just to get a 911 tape. You would sit in custody for all that time. The only thing I'm asking you to do at this point is be nice and don't pick up any new cases. If you are incapable of having good contact with your mother, then you may not have any contact. And I'm telling you, I don't want you to have any contact with her at all. No matter what you're doing in life, no matter what, anything. You have but one mother in this world. No one else cares for you. Everyone in life wants you to fail. In fact, that's the way everyone is around here. They want to see you fail. They laugh when you fall down. No one is there to pick you up but family. And when you don't have family, you start living on the street, and then you will start doing anything you thought you would never do just to survive. The streets suck. And I'm going to tell you that you have it as good as you have now at 17. It's not going to get any easier the older you get. In fact, it gets so much worse. You get bigger, you get fatter, you get uglier, and you need a lot of money in life to be able to do anything. And if you don't have money, or at the minimum, an education, you will end up nowhere and with a number on your back forever. Life is very, very difficult. And you need someone to help you through it, especially at 17. I will give you a lawyer to help you navigate through this, but I don't want any more issues. Do you understand, man? What do you do with yourself now? Where do you go to school? Good. What year are you? I'm sorry?
Graduate 2025.
You're a senior or junior? Okay. This is going to hurt you. You need to be focusing on your studies because that's where it's at. You know, you now are setting the table for the next 40 to 50 years of your life. And if you don't set yourself good to be able to do something, this life is either going to be great or it's going to be a rotten, miserable life. What you do now sets you up for the next 50 years. So you should stay in school, get as much education as you can, because it's the only way you're going to get a lot of money. All right. Can you reach out to the MAC? Let's give her a lawyer. I'm going to have you go to Victoria, sign a reset. After that, I'm going to have to take a seat in the jury box while I get your bond condition. We'll have you sign it, and then I'm going to have you speak to a lawyer here in a minute.
I don't. Architect to the right.
You have the rep done. Do we know if mom wants to have contact with her or no? No? Okay. Lori.
Yes, Judge. I need the state to fill out plea paperwork on Mr. Webb, please.
Hey, no fugitive cases? Okay. No one wants a bond? Okay.
Did you hear me, Judge?
Maybe we should have Miss Jackson.
No, they can't.
Victoria, maybe we should have Miss Jackson with us. Instead of like having her report to a region, having her report to us.
And I just messaged them. They can see her on May 8th at 11 o'clock. So that's as soon as they can see her.
Is that
orientation.
okay?
other one is Monday,
Yeah.
Thursday.
So, what, was she pills? What was it pills? What was it? Was it alcohol?
Opiates,
Damn it.
marijuana, and benzone.
God, it makes it so much more difficult. Okay. Treasure. Yeah. Let me see. Oh, Robinson. Right. Frazier. I think it was Frazier. Lori, talk to me if you're ready.
Can you hear me, Judge? Can you hear me? They can't.
Counsel, please. Is your gentleman on the docket today? No.
Somebody here.
249.
If you can sign your sign here.
Oh, hold on. 249
2470.
2470. Kenneth Green, that's it. Okay.
What I would like to do is I subpoenaed for police reports. There may have been a technical defect with the subpoena, even though it was returned. I'm going to reissue a subpoena. And what I would like to do is, assuming that the subpoena is ignored again on the day that we are set for docket May 22nd, just to have a contempt hearing set. Obviously, if they respond to this, that's the hearing. In this case,
What do you subpoena? What do you want to subpoena?
I want to subpoena
Everybody.
police records for every incident between, because like Mr. Green and his family, I filed 5 police reports against them. And the families tried to get the reports that they've not been tendered to the family. I just want the
Wait. So Mr. Green and his family have filed police reports against the complaining witness.
Yes. And because the complaining witness is a defendant upstairs, and Mr. Green is the complaining witness upstairs. And what's going on is there's been a series of incidents between Mr. Charles, the complaining witness, and Mr. Green. And this is the one where I got the bullet and all that. I want the police report because Mr. Green was arrested whenever he was at the precinct 4 to report getting shot at by Mr. Charles. The same transaction. And I'm trying to get a copy of that report to either see that it was taken or to conclusively establish that it was not taken so it can get reported again.
Judge, if I may, I apologize, go ahead.
No, go ahead. And it's one of those, I believe it is material to this case.
I'll give you a chance to respond, for sure. But my question to you is, do you know affirmatively that they actually made a police report? Because
attempting to. That was his purpose. Because he was
so he went to the police department to file a complaint.
Yes.
Right. And was he was arrested there, or
he was arrested there?
Why?
Because Mr. Charles had called in and reported the terroristic threat. So when they took Mr. Green's name,
they already had I guess there was already a warrant out for his arrest at the time.
Well, they were attempting to get the warrant. He had outstanding traffic tickets. So they held him on the traffic. They had a warrant. He had a warrant for traffic tickets.
Okay.
They held him on the traffic ticket warrant until the warrant for the terroristic threat could get signed.
Well, they can't. I mean, they can't. I mean, I don't know how long they can hold him for that to happen. You know.
It was real. They were in the process of getting it, so it was real transient.
Okay.
And so I don't have a issue with it.
I don't know if they even created a report.
See, that's what I'm trying to find out. It's one of those, either they have a report and I need it, or they don't, and they respond, no report, at which point I get him to go in and make the report. And
at which point, what? You want them to go make a report?
He went to Kenneth Green, went to make a report, because it's the same transaction. He's reporting where he got shot at in the same transaction where he allegedly made the terrorist threat. And if that report never got taken or never got filed, he obviously needs to refile it, because that is a separate crime. And it's one of those, there are also 4 other reports which have been made. And he's got a case number, so I think at least a partial report was made on him getting shot at. I want a copy of all 5 police reports, all 5 case numbers. Now, the state of Chicago is going to argue, and I agree with them, I did not give 10 days notice, so that the subpoena is technically defective. But the constable's office still has a duty to quash for it being technically defective, and they just ignored it. So what I was going to do is get it reissued with the appropriate 10 days notice, because because it was sheriff's constable's office. They executed it same day.
It was not executed.
It was.
It would be in deeds if it were executed.
I can show you where it was executed.
I can pull up deeds.
It is right here.
Okay. All right.
This is one of those, I keep telling you it's executed. 113-726-510.
Wait. Okay. What number is that?
Sorry, Judge.
I've got the document right here showing it was executed, and I am 100% happy to get it re-executed, so they will have the requisite 10 days. And then that way they would have failed to respond to the first subpoena, which was executed same day. So I have no reason to believe the second subpoena couldn't be executed same day, Monday, which would give them 10 business days to respond by the 22nd. So they will either responded and given us the records, or at that point they will have ignored 2 subpoenas, and a contempt hearing is appropriate because of disrespecting the court's authority twice.
Judge, the first subpoena was requested on April 10th for a subpoena that's frankly overbroad, vague, makes no sense, is not the appropriate method to get any potential reports that his client and his family's relaying may have existed. But he asked that the officers appear on the 12th. There was no subpoena executed, Judge. There's no disrespect to the court being had. If counsel would like to, and again, I have to play by the same rules. When I ask for a subpoena, I have to give them 10 business days to get that, right?
Executed.
That's not executed. That's just the subpoena.
No, it says returned.
Where does it say returned, counsel? Show me that.
Tell you what.
Show me where it says returned.
And if you've got a problem with it, we can argue about it on the 22nd.
Judge, he can submit a PIA request for whatever. He could also call precinct 4.
I think that the PIA request is the proper way to do it, don't you think?
They've got defenses to the PIA request because it's ongoing litigation. They've got defenses to the PIA request because it's ongoing investigation.
Have you filed a PIA request?
I have not, but the family has. The family has attempted to get the documents on several times. There are defenses to the PIA request which is why I asked for the subpoena.
A subpoena that was not executed. I don't know anything about what his client and his family submitted, but presumably if they've correctly submitted a PI request and did not get any documents that you're looking for, they don't exist, right? And this is what you're showing me. This is not an executed subpoena.
What cause number are you looking at there so I can pull it up?
24924.
On the 2470? That's it?
Yes, Judge.
Okay, so that's the terroristic threat.
But even if I were to agree with everything he's back, the state saying it's matched, that I'm going to get it re-executed.
Executed, not re-executed. So,
all right.
I see an application, but I don't see that a return where there was a signature that someone actually received it. Do you have a return that has a signature that?
And the state can argue we could either re-execute it or not.
So, I mean, Dylan, are you?
Here's my thing. This is not the appropriate avenue to get whatever files he thinks may exist. Okay, and if he's going to try to throw officers under the bus for something that they don't even have, I'm going to have to step up and say this did not occur. Additionally, your subpoena is asking for, I'm going to go ahead and just quote it. The case numbers and complete files for any case number within the past 12 months with location, address, folder, right? That's far too broad.
Be fair, read the rest of it, which
Okay,
actually gives
sure.
5 case numbers.
I'm reading it right here.
So there's specifically 5 case numbers that I am seeking the reports for.
Judge, I'm just saying, if he submits a PIA request, if there are files, he will probably get them.
I will not, because there are valid defenses to the PIA request, and with all due respect to the state, they don't get to control how I practice law. It may be an unorthodox method, but it's not an impermissible method. And the state is basically arguing, I'm not doing it the way that it's normally done, which is not within their purview. If they've got a problem with
File
it.
your subpoena.
Yes, but I would also like to concurrently get it set for a contempt motion.
I'm not going to set something like that for a contempt hearing when you're doing it on the first time. I don't know how they're going to respond. I don't know if they're going to file a motion to quash. I mean, that's me threatening them when they've done nothing wrong so far. You know, that's not a nice thing to do.
Well, it's not nice for people not to take evidence. It's not nice for people not to turn over police reports when.
Let's see. I mean, we don't know yet.
Objectively, the Mr. Green and his family has asked for the reports and not to give it to them. So if you're talking about not nice, precinct 4 has been not nice throughout all of this. And as far as the PIA,
I'll give you a chance.
as far as the PIA, there is objectively, statutorily a defense. So whether or not normally a PIA request is the way to go, knowing that there is
Mr. Geiger, I'm telling you, file your subpoena. If you make it overbroad, they're probably going to file a motion to quash. So be careful, because then it's going to take even more time. I would probably be like what Dylan is saying, be specific in what you want. Don't be overbroad. You're asking for any and all and absolutely everything, because at that point, you know, if there's evidence there, whatever it may be, they're gonna deny your request. Make it specific, like so just say, I want an offense report. I want to know that something was filed. If you ask for absolutely everything in the kitchen sink, they're gonna have a problem. That's what I'm saying. Make it specific, ask for your 5 things, and if they have an issue, then we can have a hearing, you know? Let's do that. But he's right. Make sure, number 1, you give them the statutory amount of time, and it's got to be executed where they have the signature on it as well. So we know that they actually got it and received it.
In that case, what I would like to do is, instead of having the sheriff's office execute it, I would like to have my process, I would like to have my investigator.
Sure. Okay.
And then.
I'm okay with that.
All right.
Yeah. Okay. For sure. Hey, Mr. Garris, you've got Henderson, I see. Tell me about Mr. Henderson.
Yes, Judge, I got appointed here. This case is just set back.
Okay.
And Mr. Petroff and I approached on bond, and you said one of his bond is 2,500 and the other 2,501. I think he's made a bond and now it's his first appearance following that. So I think maybe we need to get bond conditions.
All right, Mr. Henderson, come up.
Yes, sir. And I don't think we've met before. Brian Jones. What's your name? Brian Gaines. Thank you, sir. And so just listen.
No, you picked up one gun case. I asked you not to have a weapon. You picked up another gun case and I put you in jail. I don't want you to have a gun. Whatever you're doing in life that necessitates you having a gun, don't do it. Don't have a weapon. And for God's sakes, don't pick up any new cases. Otherwise, I'm going to make your bond really, really high. Do you understand? Okay. You have a lawyer. You ever have any issues, talk with him. He will take care of you. We will just give you a normal reset for at now. You mind filing no weapons, please, on both cases on Mr. Henderson? We will have you sign the court order promising us you're not going to have any weapons, and after that, you guys are free to go. Okay? All right.
Thank you, Judge.
Victoria, did you have Mr. Henderson sign a reset yet or no? Okay, so let's have you sign a reset. After that, we'll just get you in the jury box while we get your bond conditions. After that, you'll be free to go. Yeah, probable cause already been done.
It's been done.
Yeah, all we need are conditions that he not have any weapons. That's it.
Thank you.
Okay. Hi. Are you here for Garza's office?
Yes,
right?
Eric Garza's office. Joe Monte, Your Honor.
Hi, Joe.
I'm here on Eric Garza's office. The case is pending. The client's in the box. His name is Robert Fleischer.
Correct.
Your Honor, I understand there were some conditions that you wanted him to sign and go over. And I didn't know if probable cause had already been done or established here because he was telling on this. I wanted to kind of hear it because I wasn't sure because he says he owns the vehicle and he's showing the proof he owns it. So I just wondered what the probable cause stated because.
So what allegedly happened is that he put a tracking device, an air tag onto the vehicle and was tracking where she was going to places where she was going. And I think there were also perhaps threats as well. I don't remember that specifically, but
He admitted to placing the air tag in the car and requested it back, and she refused to give it back.
I think the only issue I had, Your Honor, is what the probable says because he owns the vehicle. He's paying on it. It's his vehicle. He's on the title and everything.
I don't know. Right, be that as it may, I think she was in use of it or whatnot.
Apparently, it was a former relationship, so he had her on the title as well.
They have a child in common.
Yeah, they have a title. They're both on the title, but he is on the title. He's the one paying. He is the owner of the vehicle. So I was wondering.
So regardless, Joe, I found probable cause. The only thing I'm asking him to do is not have any contact with her.
Yes, sir.
That's it. Okay. And not to be in possession of weapons.
Yes, sir, we'll make sure that.
We'll just give you a normal reset and then you guys, Pavel's not here today. So, I mean, we'll give you guys time to work it out and then whatever you need.
That'd be good. Thank you, Your Honor. Sorry I was delayed. They called me.
Don't worry about it. I'm happy that you came. Don't worry about it. So I think, are we ready for Fleischer to sign this? I thought I saw, oh, hey, do you know how to file a MOA or no?
Yes. Well, I just go.
So yeah, can you file the MOA on for Mr. Fleischer, please? So the only thing I need now is for him to send the MOA and then that's it.
Okay.
It has not been filed yet. I think that we've had him sign the bond conditions, but the only thing I want is the MOA and then that's it.
Will it be the child? Your Honor, will there be exceptions for visiting the child? They have a child together, so.
I'm okay that he can, whatever he wants with the child, I'm okay, but just I don't want him to have contact with her.
Yes.
That's
Do it with third parties or something.
right, for sure.
Thank you, Your Honor.
Thank you, Joe. No, we need bond conditions too. Miss White, come up, ma'am.
Yeah.
Okay. If you want to take a look on the TV. Will, that's Will. He's been appointed to represent you. Do you have a cell phone? What is your cell phone number?
09
409 256
894.
0894. He's going to get in contact with you. It's your responsibility to stay in touch with Mr. Vaughn. He will help you navigate through this. If he tells me that he can't get a hold of you because you're playing games, you're not responding to phone calls or text messages, I will issue a warrant for your arrest. Don't pick up any new cases. Don't violate conditions and stay in contact with Will, and things will go well. Okay?
I'm texting you right now, Miss White.
Yeah, I wanted, let me see. I don't see that an order for protection was filed in Fleischer. Did you file one by chance? Okay. You,
No, in process.
it's okay. Just go ahead, take a seat for me. We'll be back with you shortly.
I'll get with Victoria on reset day, Judge.
So I think Miss White's good to go, Will. So we'll just have her sign a reset and then I'll tell her that you guys get in contact with her later, huh?
That sounds good. Yeah, I've already texted you, Miss White. So when you get out, please get in touch with me. All right. All right. Thank you, Judge. No.
Yeah, for sure. Come on up.
Mr. Gerard.
Hi, Mr. Gerard.
How you doing?
I think GER.
Okay. So, sir, you are charged with 2 cases. You're charged with theft. You're also charged with criminal trespass. You've worked out an agreement where they're offering you 7 days in jail with credit for the 7 days that you've done on the trespass. They will dismiss the theft case as a part of your plea bargain agreement. Is this how you understand it?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this, undo this, challenge this. Mr. Gerard, you now have more than 2 misdemeanors going on your record. From now on, you will be facing a minimum of 90 days in jail if you ever pick up another misdemeanor, no matter what it is. Do you understand?
Yeah.
How do you plead to the offense, sir? I will find you guilty. I will follow the agreement. Good luck to you, sir. Thank you so much. Ricardo.
Yes, may I approach?
Yeah.
Judge, I'm approaching on a rollover from yesterday. You were kind enough to reset it so you could come, Oscar Alvarado, BBR. The only thing is, can I talk to him by chance in one of the rooms before we approach?
Sure.
Okay, so I'm gonna pull him. Thank you, Judge.
Yes.
Señor Alvarado, venga para acá, por favor.
Do you know why you're here?
¿Por qué estás aquí? Oh, I think I hear you straight there, Judge.
Hey.
There he is.
The man, the myth. Come on. Come on, legend.
It's me again, Luis.
Hola, buenos días. O buenas tardes, perdón. Soy Luis. Mucho gusto. Mira,
Why are you here, Mr. Alvarado?
¿por qué está aquí, señor Alvarado?
Por cometer delito, manejar borracho.
Well, for having committed a crime and driving drunk.
No.
No.
What's the one thing I asked you? Sorry. The one thing I ordered you not to do.
Que no hiciera, señor.
No lo he hecho solo.
¿Perdón?
No lo he hecho.
Well, I haven't done it.
Ya, pues, tengo la máquina, me asignaron la máquina.
Okay. I
Entonces
have the
no lo he hecho.
machine. I've been assigned a machine, and since then I haven't done it.
I have here that you've tested positive on 3 different occasions. I have here that you blew 13 at 5:47, a .09.
13 de abril, a las 5:47.
At 2 hours later, a .07.
07.
And then a week later, a .03.
03.
What is the one thing I ordered you not to do?
Le ordené a usted que no hiciera, señor. Yes.
What did I order you not to
Le
do?
ordené a que no hiciera, señor.
Pero no fue el que tomé. No tomé.
Well, I didn't drink.
Sino fue que pues tuve un problema en mi dentadura, se me quebró.
I had a problem and I had some fractures in my teeth.
Tomé pastillas para el dolor, pero no se me calmaba.
And I
Luego,
took some pills for pain, because it wasn't calming
luego
down.
me puse tacos de alcohol.
¿Te puso qué?
Tacos de alcohol.
¿Qué es eso? Tacos.
Alcohol medicado.
And I put some medicated alcohol pads on my wounds.
Todavía ando una parte del diente.
If that were the case, that you put some kind of alcohol on a swab and put it to your tooth, that alcohol dissipates in a matter of seconds.
Cuestión de segundos.
Don't pee on my leg and tell me it's raining.
En la pierna y me diga que está lloviendo, señor.
Entiendo.
I understand, Your Honor.
I told you not to drink.
Que no bebiera.
I have here that you did. You now will stay with me.
Estar conmigo.
He goes with you.
Se va con él. Váyase con el oficial.
Well, I guess I'll talk to you in a minute, Judge.
I'm just shocked that nobody in my chat believed him. Guys, he's telling the truth. He had alcohol on a thing that he rubbed on his tooth. That's absolutely what happened all 3 times.
No, she hasn't.
I would just want Plea and Bernard.
You already worked there with them?
Yes, sir. The paperwork.
Mr. Bernard, tell me, what you want to do is you want me to accept this probation, a deferred adjudication right now. But my question to you is, you couldn't even stay out of trouble while you were out on bond. So how are you going to be able to make this? I sincerely believe that everybody should have a chance, at least once. But you can lie to me, but you can't lie to yourself. Because the problem is you're entering into it's a difficult probation. One of the things that you will have to do is what's called a Batterers Intervention Prevention Program, a BIP class. This is difficult because it's 18 weeks that you have to attend every week, once a week for 18 weeks. And if you miss one class, they kick you out. The problem is that if you enter into this probation with me now, you're basically entering into a contract with me and with the state of Texas. And that if you violate this agreement, you're looking at an entire year in jail. I don't know what's going on in your life. I have no idea. Can you really make this? You sure? That also means you may not smoke weed. You cannot drink alcohol. So if you're one that lights up every day, it's going to be an issue. Understand? You cannot pick up any new cases. You will do what's called a TRAS, which is an evaluation to see what other conditions you may need. You must fulfill those conditions. No weapons, no threatening, harassing, abusive contact with Quaidana Donawan, and a $100 one-time donation to the Houston Area Women's Center. This is a 13-month probation, and I will make you a deal that will make this even sweeter for you. If you get everything done quick, I will take you off in half the time. I want to reward you for doing well. But if you don't do well, you pick up a new case. I'm telling you, I'm going to put you over my knee and I'm going to spank you like a little child, but it's going to be with a ton of jail time. You authorized me to do it for an entire year if you muck this thing up. Are you sure that you want to do this, Mr. Bernard? I'm sorry?
I did too. Yes, sir.
What do you do for a living?
For work.
What do you do for work?
Interior handler.
How much money you make a month? Do you know why we have people in jail? Do you know why we have people in jail? Mr. Bernard?
Because I couldn't fix them.
No self-control. When you get upset, you wig out and do whatever the hell you want to do. Life's not like that. There are consequences. And you're lucky that you're not going to jail today. But I'm telling you, there is a humongous consequence here if you fail to exercise self-control from now on. You understand? Sure.
Just that I, was appointed this morning and have not had an opportunity to review any discovery, talk to my client about that. He does want to move forward with this plea.
Do you want me to make a docket notation that's against your advice?
Yes, sir.
Do you hear? What he's advising you to do is wait to see what the evidence may have in store. You still want to do this? Once you do this, there's no buyer's remorse here, meaning that you can't change your mind after the fact. Once you plead to something, you're stuck with this forever. Are you sure? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you do this, you're stuck with us until you complete it successfully or it gets revoked. If you do something to violate this probation, I will issue a warrant for your arrest. I'm going to put you in jail. The only thing, and I'm going to bring you back out. The only thing that we're going to talk about is one, if you violated it, and if you did, how long of a jail stint you're going to be doing. And like I said, you give up almost every right known to man by entering into this agreement today. And I will tell you, Mr. Bernard, if you ever have a problem, come back and talk to me. We can always solve whatever ails you. But if you pick up a new case, or if you stop reporting, that's about the worst thing that you can do. I want to reward you. I want to see you do well. So I'm telling you, if you do everything well, if you're nice to everybody, I'll take you off in half the time. You could be done with this thing in 6 months if you really buckle down and get it done. And I will take off all your fees so you won't owe anything. The only thing that you'll have to pay for is the BIP class, because I can't pay for that for you. Otherwise I would. So there's no excuse. Get it? How do you plead to the offense? Guilty or not guilty? I will not find you guilty. I will withhold after 13 months. I wish you the best of luck, Mr. Bernard. All right, thanks.
Okay, I just let her know we're waiting on her.
All right, so that's it.
Yes.
That's a wrap.
That's a wrap. Judge spoke. I don't know. I don't know. Let's say he makes it. Let's just say this guy makes it. He makes it through. He does what he's supposed to do. They take it off of his record. That's what I'm going with. Or he misses his first class. We see him next week. Oh, man. All right, guys. Even though I was 2 hours late, thank you so much for coming out. I really appreciate it. And when you get to be that first guy's age, don't still have babies that you need child support for. All right? You're done with that. It's over. You're living your golden years. Thanks, Monica. You too. Thanks, Fozzie. I hope you have a great day, too. Hi, GSD. Legal says he's going to make all the classes but the last one. Oh, man. Carolyn has a surprise in Discord. Ooh. Thanks, Chuck. All right, guys. Behave today because it's Sunday, so you won't get in front of a judge today. All right? Behave. And I will see you next time. I hope you guys have a great rest of your weekend, whatever's left. And thank you so much to my mods. I love them.